Thanks for tuning in to your daily dose of quick real estate updates, local housing trends, and market data, plus tips, tools, and strategies to help you buy, rent, or invest with confidence. You're now getting ready with RealiCare Reports, powered by the innovation team, Cami and Rex. Now go grab your favorite morning breakfast, coffee or tea, and let's enjoy today's episode.
Imagine this for a second. You walk up to maybe your small business, or perhaps even your own home, and you realize someone's there, someone who absolutely shouldn't be. Not a guest, not a tenant, just an unauthorized occupant. That really uneasy feeling, the violation, the sheer frustration of not knowing how to quickly get your own space back. It's something property owners unfortunately run into. So today we're going to dig into Florida's Senate Bill 322. It's a pretty new piece of legislation that looks set to significantly reshape property rights in the state. We've taken this, well, let's be honest, pretty dense legal document, and we're going to pull out the key insights for you, give you a shortcut to understanding what it really means for property owners and for the public, too. Our goal here is to bring you those aha moments, to clarify the legal jargon and just make sure you're fully up to speed on this really timely subject. Okay, so let's kick things off. What exactly is the core problem this bill is trying to solve?
Well, at its heart, this bill is tackling that difficult issue of people unlawfully occupying properties. You often hear terms like squatters, or maybe even the situations involving like fraudulent leases. And what's interesting here is it's not just about simple trespass. That has its own clear legal path, right? This bill seems to zero in on those more complex situations where getting someone removed through the traditional legal channels can be incredibly slow and expensive for property owners. It can drag on. So this new law provides a specific alternative, an expedited remedy compared to those often sluggish existing pathways. It's designed to cut through some of that delay.
That makes a lot of sense. Yeah, those delays can be absolutely crippling for someone trying to manage a property. Now, you mentioned this new bill introduces a whole separate section for commercial property, which we'll get into, but it also seems to clarify and tweak the existing process for residential property, too. So for a homeowner listening right now, how would they actually use this updated process to, say, immediately remove an unlawful occupant from their house?
Okay, so the process starts with a very specific document. It's called a complaint to remove persons unlawfully occupying residential real property. This complaint, it has to be submitted to the sheriff in the county where the property is actually located. And importantly, this isn't just, a simple form you fill out and sign. It's a verified document. It's submitted under penalty of perjury.
Okay, that phrase, under penalty of perjury, that sounds quite serious. What does that actually mean for the owner filling this out?
It is serious. It's a critical safeguard, really. When you submit something under penalty of perjury, you're essentially swearing that the statements you're making are true, almost like testifying in court. So it means that if an owner knowingly puts false information on that complaint, well, they could face some pretty severe consequences, not just potential lawsuits, but maybe even criminal charges. It sets a very high bar for accuracy.
And what kind of things do they have to swear to?
Well, there are several points, 13, I think, in the residential section. Key things include affirming they are the actual owner or an authorized agent. They also have to state that the property was not open to the public when the person entered. That's an important distinction. And that they've already directed the person to leave, told them to get out. Crucially, they also have to affirm the person is not a current or even a former tenant who might have had a valid lease. And if a lease is produced, the owner has to state it's fraudulent. It also clarifies things like the person isn't another owner or a co-owner or an immediate family member. And importantly, that there's no pending litigation, no ongoing lawsuit about the property between the owner and the occupant.
Right, covering all bases. Now, I saw something in the bill text that really jumped out at me regarding residential properties. It seems the owner's complaint actually authorizes the sheriff to enter the property, even using force if needed, and search it to remove people. That sounds like a huge grant of authority.
It is. And that's precisely where the expedited nature of this really comes into play. Think about traditional eviction processes. They usually need a judge's order, court dates, the whole legal process before law enforcement could physically remove someone. This provision, it essentially allows the sheriff to act immediately, based solely on the owner's verified complaint, their sworn statement. It's designed to be a lightning-fast mechanism, bypassing those potentially lengthy legal steps.
Wow. So for an owner dealing with this, that could be the difference between, months of legal battles and maybe getting their property back in days
Yep.
or even hours.
Potentially, yes. That's the intent. But, as you rightly pointed out, giving that much power based on one person's statement raises the question of accountability, doesn't it?
Absolutely. It seems like a powerful tool, but open to misuse if someone isn't truthful. So what are the checks and balances? How is the owner held accountable if they, say, wrongfully use this?
The bill is very explicit about that. The complaint form itself actually states that the owner understands they can be sued if they make false statements in that complaint, or if they wrongfully use this procedure altogether. If that happens, they could be on the hook for some substantial liability, actual damages the person suffered, penalties, court costs, and importantly, the other party's attorney fees. So while it's a strong tool for owners, there's a pretty significant deterrent built in against abusing it. That's the crucial check and balance.
Okay, that makes sense. So that covers the residential side updates. But you mentioned earlier a big part of this bill creates a whole new framework specifically for commercial properties. Why the separate section? Do businesses face fundamentally different issues here?
That's a really good point. If we kind of zoom out and look at the bigger picture, commercial properties definitely face unique challenges. Unauthorized occupation there can lead to immediate and often severe business disruption. Think about the economic loss. Imagine someone unlawfully occupying a retail store or maybe a restaurant or an office space. That's instant lost revenue, potential damage to reputation, safety concerns for employees or customers. So this new section, Section 82.037, it creates a direct, immediate remedy specifically tailored for that commercial context. It recognizes that urgent need to get a business operational again. And similar to the residential process, the owner or their authorized agent submits a verified complaint. This one's called Complaint to Remove Persons Unlawfully Occupying Commercial Real Property, again to the sheriff. The conditions they have to affirm are very similar, too. They need to confirm ownership, state the property wasn't open to the public when entry occurred, that they directed the person to leave, and confirm there's no valid tenancy or pending litigation.
Are there any key differences in what the commercial owner needs to state compared to the residential one?
The main practical difference is that the commercial complaint doesn't include that clause about the occupant not being an immediate family member, which, makes sense in a purely business setting. That's typically not relevant.
Got it. So once the sheriff receives this verified complaint for a commercial property, what happens next? How fast do things move?
The law says the sheriff, upon verifying the complaint appears legitimate on its face, must, without delay, serve a notice to vacate immediately. They can hand-deliver this notice to someone on site, or if no one's available, they can post it prominently on the door. And once that notice is served, the sheriff is then required to put the owner in possession of the commercial property, essentially give them back control. The sheriff also has the authority to try and verify the identities of anyone they find occupying the property. And they can actually arrest any person found there for criminal trespass, or if they have outstanding warrants, or for any other legal cause they discover.
So the sheriff isn't just serving papers, they're actively involved in the physical removal and can even make arrests on the spot. And it sounds like there might be costs involved for the owner beyond just filing the complaint. Can the sheriff charge for these services?
Yes, exactly. The statute explicitly states the sheriff is entitled to a fee for serving that notice to vacate immediately. And beyond that, the property owner or their agent can actually request the sheriff to stand by to keep the peace. This would be while the owner, say, changes the locks or removes any personal belongings left by the unauthorized occupants, taking them to the property line as the law specifies. For that standby service, the sheriff can charge a reasonable hourly rate.
Okay, and what about liability? If personal property gets damaged during this removal process?
That's addressed too. The bill provides immunity for the sheriff. They are not liable for loss or damage to any personal property left behind, and the property owner or their agent is also not liable, with a key exception, unless it's found that the removal itself was wrongful, meaning it wasn't done in accordance with the specific legal section. So again, there's that protection for owners acting properly, but accountability if they misuse the process.
Okay, so we have these expedited removal processes for both residential and now commercial properties. But beyond just getting people out quickly, does this bill add any more teeth to existing laws? I heard something about enhanced criminal penalties.
It absolutely does. This bill significantly strengthens the legal consequences by amending other Florida statutes. It adds more serious repercussions for certain actions. For instance, it amends the law on criminal mischief. Now, if someone unlawfully detains or occupies any residential dwelling or commercial property and they intentionally cause $1,000 or more in damages, that act is elevated to a felony of the second degree.
A felony of the second degree. Just to put that in perspective for listeners, what does that actually mean in practical terms? How serious is that?
That's a really important point to clarify. A second-degree felony in Florida is a serious offense. It can carry a potential prison sentence of up to 15 years. So what might have previously been handled perhaps as a misdemeanor trespass or maybe minor property damage, if that damage hits the $1,000 threshold, and frankly, causing $1,000 in damage isn't that hard if someone is intentionally damaging property, think broken appliances, windows, graffiti, it now becomes a major crime with potentially very significant prison time.
Wow, that's a substantial escalation.
It is, and there's more. The bill also targets fraudulent activity more directly. It amends the statute related to fraudulent sale or lease. Under the new law, if someone lists or advertises property for sale when they don't actually have legal title, or if they try to rent or lease out a property without lawful ownership or proper leasehold interest, that itself is now a felony of the first degree.
First degree, that sounds even more serious.
It is. A first-degree felony can carry up to 30 years in prison. This provision really seems aimed at cracking down on those scams where people try to, say, collect rent on a property they have no legal right to, a growing problem in some areas.
Okay, so stronger penalties for unlawful occupants causing damage and for fraudulent actors. What about the flip side? We talked about accountability for owners misusing the removal process. What happens if someone is wrongfully removed? Do they have any specific recourse under this bill?
Yes, and this is a vital part of the balance the legislation seems to be aiming for. The bill provides a pretty robust civil remedy specifically for wrongful removal under these new procedures. A person who is harmed, who is removed incorrectly, can sue, and if they win, they can be restored to possession of the property. They can also recover their actual costs and any damages they incurred because of the wrongful removal, plus court costs and reasonable attorney's fees. And on top of all that, there are statutory damages equal to triple the fair market rent of the property.
Triple rent. That sounds like a significant deterrent.
It's meant to be. And to ensure these cases are handled quickly, the law also requires the court to advance the cause on the calendar, meaning give the case priority. So yes, it's a powerful deterrent designed to make owners think very carefully before using these expedited procedures and ensure they're doing so legitimately.
So when you step back and look at it all,
well, if you connect it to the bigger picture, these new criminal penalties on one side and these strong civil remedies for wrongful removal on the other, it suggests a pretty comprehensive approach. The idea seems to be speed up the process for legitimate owners dealing with genuinely unlawful occupants, but also strongly deter fraudulent schemes, and provide real protection and recourse for individuals who might be wrongfully targeted by these new, faster methods. And the bill also makes sure to state, that this doesn't limit existing law enforcement powers to arrest people for other crimes they might encounter, like vandalism, theft, or other offenses during these situations.
we have certainly taken a deep dive today into Florida's SB 322. We've really unpacked how it aims to streamline the process for property owners needing to remove unauthorized occupants, both from homes and, maybe more significantly, from commercial properties now, too. And we've also seen how it introduces some pretty hefty new penalties for people who unlawfully occupy or engage in property fraud. But importantly, it also seems to simultaneously build in protections and quite severe penalties for any owners who might be tempted to misuse these new powerful tools. So this legislation really appears to be trying to strike a tricky balance, doesn't it? Empowering property owners to reclaim their assets quickly while also putting up guardrails against potential abuse. Now, as you reflect on everything we've discussed, here's something to maybe chew on. How does a law like SB 322 navigate that really complex, sometimes gray area between clear individual property rights on one hand and the broader societal implications of, well, immediate removal on the other? Especially when that line between who is truly an unauthorized occupant versus maybe someone who believes they are a disputed tenant. When that line might sometimes seem a bit blurry. What could these new, much faster processes mean for the future of property disputes and perhaps the legal landscape around housing and commercial space moving forward?
Well, that wraps up today's episode of Reality Reports, where real estate meets real life. For more updates, tools, and insights that will help you buy, rent, or invest with confidence, be sure to follow, subscribe, stay connected, stay informed, and stay ready. Until next time.